everyone, and welcome back to the Immigration Insights podcast, videocast by the GT Immigration Group. I'm joined today by my partner, Jennifer Hermansky, and we are going to talk about site visits in the EB-5 program today. Hi, Jen, how are you?
Doing well, ready to talk about visits.
Let's get right to it. So in 2022, Congress introduced the Reform and Integrity Act, and the impetus for this change to the EB-5 law, which had not been changed since its introduction in 1990, was the desire to create checks and balances in the EB-5 program to ensure that investors who were putting money into the United States would be assured that the money was going to the actual construction and development of the EB-5 project that they were using to get a green card, to avoid malfeasance by bad actors in the space, and to create a more regimented program, if you will, in the EB-5 context. We can say that at the height of the program, post 2008, obviously we had the real estate crash in the US, and many developers turned to EB-5 financing as a way to get low interest money into development projects. However, there was no oversight in the EB-5 program. Yes, the Securities and Exchange Commission got involved at certain points when there were clear-cut cases of fraud, but there were no real reporting mechanisms in the EB-5 space. So the goal of the RIA, when the EB-5 program was extended, was to create a series of measures to really monitor how money is spent. The first thing that was introduced was this new requirement that there had to be a fund administrator or audited financials of the project involved in the capital raise. The second requirement is that regional centers and their projects have to submit an annual compliance filing to the USCIS, explaining to them their progress over the year. And the third requirement was this site visit requirement. Now, the site visit requirement now became mandatory, but it wasn't actually new in the EB-5 context. You and I had been involved in EB-5 site visits on behalf of our regional center and project clients well before 2022. So can you tell us a little bit, Jen, about what we went through when we actually met with the USCIS? And we actually conducted site visits with the head of the EB-5 program office, which was amazing. So give us a little bit insight pre-2022, what the site visits looked like and what they're going to look like now under the RIA.
Sure. So before the RIA was passed in 2022, the concept of audits or site visits was not written into the law at all. And in fact, they had never passed any regulations either at USCIS to mandate audits of regional centers or projects or site visits of projects to make sure that there was actually activity going on at the different sites. And as a result, there was a little bit of pushback sometimes from individuals involved in EB-5 programs that this isn't a real requirement. What is the repercussion if we don't submit to an audit or a site visit? Or what happens if we miss something? There was no teeth behind this requirement. USCIS would contact the regional centers and basically hope that they would agree to submit to an audit so that they could come in and look at the type of records that regional centers were keeping about the projects under their sponsorship. So pre-2022, the audit process just started by USCIS notifying the regional center via a notice to the regional center and its council, if it had one, that they would like to come in and conduct an audit of the regional center. And before they come in person, they sent a written request list of documents that they wanted to see ahead of time. So those documents might focus on the new commercial enterprises, the EB-5 funds that are being sponsored by the regional center, documents surrounding the number of investors in each fund, the securities documents for the EB-5 funds, also the status of the project, documents to show the flow of funds between the EB-5 new commercial enterprise and the project. And they might also ask for job creation documentation or maybe other tax returns or things like that. Generally, things that the regional centers had and should be keeping for the I-829 petitions of investors. So the audit process would start by this notification. They would give you a certain amount of time to respond with the written materials that they asked for, and then they would review those materials, and then there is a time that gets set up for the USCIS officers to come in person to the regional center's offices and then review materials. And interestingly, in some of the audits that we were involved in, they actually told us in advance what presentations they wanted the regional centers to make to USCIS during the meetings. They actually gave topics. You should have one of your accounting staff make a presentation on how your record keeping for the flow of funds or job creation evidence. You should have someone on your compliance team come and talk to us about how you due diligence investors. Interestingly enough, even though at the time there was really no ability for USCIS to really monitor securities compliance, they were sort of asking those questions. Probably a lot of this knowledge actually formed the basis of the RIA now. So they would notify you of certain materials and subjects that they wanted to hear from the regional center managers or owners on, and then they would come and there would be a schedule. We're going to have these presentations, and that's going to take up X amount of time. And then after you present these materials to us, we're going to stay extra time on site, maybe a day or two more. And we want to review these materials that you have. And interestingly enough, they wanted to review sort of everything in paper, just like they do at USCIS normally. So there was some preparations by the regional centers to pull the files or a sampling of the files that USCIS asked for. And then the 2 to 3 USCIS officers would stay on site and actually review those materials and ask any follow-up questions. And then after the audit, if they had any final questions, they would let you know. And then otherwise, they would just send you a sort of nondescript letter. Thank you. This audit has occurred. And that was sort of it. There was no real finding. There was no sort of consequences. Maybe they would make recommendations to a regional center if the regional center had bad record keeping or wasn't prepared. But in general, now that we have the RIA, maybe the USCIS learned from some negative site visits that it had that these things need to be put into the law, and these are the records that should be kept, and these are the records that we should have the authority to actually audit. So when the RIA was passed, we now have these two concepts actually. We sometimes refer to them as site visits, but the statute also discusses audit. So there's an audit of a regional center, and then there is a site visit of a new commercial enterprise or a project. So an audit under the law now in the RIA is supposed to occur for a regional center at least once every 5 years. So that's the more involved process that we just talked about. And I think the process is essentially the same. It's just that now there's actual legal authority for USCIS to do this. And if a regional center doesn't submit to the audit, they can be terminated. So now there's real consequences for failure to participate in the audit as required. And then the second concept are these site visits where USCIS USCIS is now required to site visit a new commercial enterprise or the project. Generally, it's the project, right? They go to the site to make sure that there's ongoing work happening. And the statute now mandates at least one of those site visits to each project and new commercial enterprise. So that's where USCIS sort of just shows up. They're supposed to give 24 hours notice now. So usually a local USCIS officer, so let's say, for example, if the project is here in Philadelphia, someone from the Philadelphia district office of USCIS, who maybe doesn't have any experience with EB-5, goes out to the site of the project to make sure that it's actually existing there. So if we said we're building a hotel in Center City, Philadelphia, they're going to go to the site and make sure there's construction work happening. Or what generally happens is this happens at the I-829 stage, and they're checking to make sure that the hotel actually exists and that it's there and that there's people staying there, et cetera, et cetera. So those are the two concepts that got introduced through the RIA and that we're seeing now. But generally, the procedure that they're following is still the same as sort of the unwritten procedure that they were following before the RIA. Now there's just a little bit more teeth to it because we actually have a statute requiring these things.
Now, interestingly, you think it's going to be a local USCIS officer, but we've seen some of these audits conducted, as I said, by the head of the EB-5 unit, site visiting herself. We've seen the chief economist come out and do site visits. We've seen officers, USCIS officers from not the EB-5 unit, but from fraud detection and national security come out and do the site visits. So it's interesting. Yes, at the 829 stage, they send the local officers, but now that the program has changed, that they haven't started these site visits yet, but they will, who's actually going to do them? And I'm not sure necessarily that it's going to be local USCIS, because as immigration practitioners, we know local USCIS officers are tasked with very different things that have nothing to do with EB-5, naturalizations, marriage-based green card applications, things where there's a local interview required of an individual and nothing really related to reviewing a corporate entity to the degree that a regional center or project audit will require.
Correct. I think where an audit of a regional center is happening, so that procedure that's happening once every 5 years, that's a longer procedure that lasts multiple days in person and that has experienced EB-5 officers at it. Whether or not that's management level individuals at the IPO office or not, it's definitely people with specialty audit backgrounds that are hired by IPO for this exact purpose. So for those more structured, every 5 year regional center audits, you're definitely going to get a more experienced person or group of individuals coming with their niches of expertise to ask questions and review those documents. Those once a time, site visits to the project, those are generally done by those local USCIS offices because they can just send someone out to the site and make sure it exists. And there's not much that the project has to necessarily do for the site visit. However, of course, we want to have someone go out and meet with the USCIS officer. It's really important when the USCIS contacts a new commercial enterprise or the regional center about a site visit that you make arrangements for someone to attend the site visit with the officer, because sometimes they will ask questions about the number of investors or job creation and things like that. And you want to be able to answer consistently with the materials that are being prepared for those investor petitions, such as the I-829. You don't want the officer just showing up to the hotel in Philadelphia and asking how many people work there, because that is maybe inconsistent consistent with the economic report and the modeling that was done for the total job creation of the project. So it's still important to get the notice, prepare with your lawyer, get someone there for that more informal site visit. But certainly, if you get the notice of the 5-year audit, then that is where you're going to work with your counsel to really prepare the materials and get everything in line, because now the audits are going to review the different statutory requirements in the law that each of these projects are supposed to be doing, right? So you mentioned earlier that there's a fund administrator required now that is going to review and sign off on the transfer of funds between the EB-5 new commercial enterprise and the project. And those records have a specific minimum 5-year holding period. So when you get notice of an audit, they're going to want to see that you are keeping those records that are required under the RIA for each of the project. And there's a whole host of things that need to be kept about the investors that are in the new commercial enterprise, how the funds were transferred and through what entities, and for payment of what expenses, and showing also the progress of each of the projects and the total job creation. There's a lot of records that need to be maintained and then organized so that they are presented in a thoughtful way when you get those USCIS officers there on site.
So what's the best way, and you're sort of leading into the question already, that our clients can prepare really for these audits? Site visits, we know, appoint a person, have them be knowledgeable, let them walk through the project guided and be able to answer questions. And if need be, counsel can also be available for that. But the audit is much more in-depth. So we talked about the financials, but what else do we need to show? Because when you and I prepare a client for this, and after we file every 956F now, we're sending a memo to clients with a long list of documents we want them to start maintaining. So we're not scrambling when the audit notice comes, that they know what their record keeping requirements are, and they're continuously updating documents for their audit file.
Yeah, I think under the RIA, there is a lot of guidance in there about the materials you're supposed to be keeping. So for each EB-5 new commercial enterprise and each project that is happening with the new commercial enterprise, they are looking to see individual files surrounding those investors. So that's a really important thing. So they are interested in the due diligence that is happening on each of the investors. They want to see you maintaining the contractual records with the investor. So the, subscription agreement, the operating agreement or the limited partnership agreement, the things that get executed by the investor, questionnaires, due diligence that you have done on the investor, those sorts of things. So that is one thing that, they're definitely looking into. Then you have the records of all of the financial records. So keeping the transfers and showing how the funds are flowing into each of the into the projects, and all of this, the backup that goes to the fund administrator, all of the bank statements and the evidence of how the EB-5 funds are being used to pay for things on site of the project. And then you have the tax and accounting documents, tax returns every year, the documents showing the investors are maintaining their required investments for the correct amount of time, and then maintaining records about the actual project, when it's hitting its milestones, when it's receiving their permits, when they are receiving their certificates of occupancies, and then all of the normal job creation evidence that is being kept about the expenditures and how many jobs are being created. And importantly, the reason why we tell our clients they keep these records is because the regional center has to submit these sort of details actually now every year on the annual filing, also the I-956G. So it's really important to keep the records consistent because you don't want you to be submitting as a regional center a bunch of information on the I-956Gs, and then for some reason have inconsistent materials, kept in your records at the time of an audit, because we know that they cross-check with prior filings that the regional center is making. And the one thing that I do want to emphasize for regional centers is there are regional centers out there that rent their regional centers, and maybe they don't manage the EB-5 new commercial enterprise or the project. They are just an overseer of the EB-5 project for regional center purposes. And where that is the case, they have to do a lot of extra work actually with the projects under their sponsorship now to make sure the regional center is collecting these documents that the EB-5 new commercial enterprise is collecting and keeping on their investors and on the project. So there has to be a lot of information sharing between the parties, and then the systems put in place to make sure that you're record keeping what is required.
Now let's go to the worst case scenario. A project fails. It's happened before in EB-5. It's basically the genesis of the Reform and Integrity Act. Now, there's two reasons a project may fail. It fails for economic reasons. It can't get its financing, it can't get its permits, it's non-successful. So maybe even the investors' jobs were created, money was spent on job creation, but the project ultimately just wasn't constructed for whatever reason. Force of nature, act of God, lack of financing, bad management. And then there's the second scenario. A project is a victim of fraud, or the project principals have perpetrated fraud. They've absconded with the money. They did not act in good faith. And unfortunately, in the EB-5 realm, there have been cases like this where investors have found themselves to be the victims of essentially theft or Ponzi scheme. So I want to talk about termination and debarment, because we hear this a lot, and we hear even attorneys in the space who don't understand when debarment and termination applies, who think that investors can request debarment. So what is debarment, Jen? When does it apply, and who can initiate debarment?
So debarment is a concept where the USCIS can disallow an entity from participating in the EB-5 program moving forward. So prior to the RIA's passage in 2022, the USCIS always took the position that they had the right to terminate a regional center's designation. But the RIA went a few steps further and said, yes, USCIS can terminate a regional center so that they can no longer participate in the program, but it can also debar a new commercial enterprise. It can debar a job creating entity or a project from future participation in the EB-5 program. It can also debar people. So there's a concept in the RIA where there can only be bona fide people involved in EB-5 capital raises. And when we're filing applications for a regional center to receive project pre-approval of a new project, they have to fill out forms about each of the individuals and the entities that are involved in the project. And the individuals have to answer questions like whether they've been involved in securities fraud or other money laundering activities. Have they been convicted of certain crimes, or investigated for certain crimes, right? And they have to answer these forms on the I-956H. Now, those questions go to the heart of whether these people are bona fide individuals involved. And so now the RIA says we have the right to debar these people from future participation in the EB-5 program. And where there is a debarment based on a bad actor scenario, the new law may give the right to the investors to reassociate themselves with a new commercial enterprise or a new regional center in order to continue on in their process. That wouldn't have been possible in the past. It's very unfortunate. Before the RIA's passage, there are many individuals who might have been victims of, fraud or scams that just have to reinvest again and start all over, which is very unfortunate. They lose a lot of time. If their children turned over the age of 21, they may have aged out and they have no recourse in maintaining or getting a new green card with their parent. But now the new law has changed where USCIS debars an entity because there was a bad actor. It's possible that maybe the investor can continue with a new commercial enterprise or retain their priority date. And even where a child is turned over 21, they can potentially file a new petition with a retained priority date and have the child participate within 1 year of USCIS making a debarment finding. So it's at least they put some protections in now to help these investors. But importantly, many interest groups, including AILA, the American Immigration Lawyers Association, IIUSA, various organizations have been asking USCIS, how do we get an entity debarred? Can the investors request it? Can the regional center request it if they discover malfeasance by one of the projects? And basically, USCIS has said, no, only we can determine when there is going to be a debarment. And the debarment is only based on bad actor things. So diversion of funds, fraud, misuse. It's not going to be a debarment where the project has just failed. So those examples you were giving, act of God, not sufficient financing, failed to get a permit. Those are just normal course of business things. Not every project is going to be successful. These are real investments, right? Matter of Azumi, precedent case decision says these have to be real at-risk investments. There is always a chance of loss of the funds, and loss of the funds on its own, absence malfeasance, is not going to amount to a debarment scenario. And as a result, we don't really know of any actual debarments that USCIS has made. They clarified that the investor can't really ask for it. They have to be the one doing it. And where they choose to not debar an entity, then the investors are sort of left with no recourse except for starting anew and filing a new application.
And sadly, we've dealt with investors even recently who invested in projects where their funds were misused and they had to file new petitions. And, in those cases, and it's horrible because some of the dependents have aged out and now they have to either choose to give their adult child the money to make an investment or to do it as a family and let the child find a sponsorship on their own. So it's a very, very difficult choice. And you're right, we haven't seen debarments yet by the USCIS. It'll be interesting to continue to monitor this and see how they implement it. And whether investors have to get together to get attention of the USCIS to do that. Do they have to report fraud to the SEC? Does there have to be an SEC investigation for them to debar? Does there have to be a lawsuit filed in federal court against a bad actor for fraud, a civil action, in order for the USCIS to debar? Does it have to be a final judgment? We really have to see how they're going to apply the standard, and we really haven't seen it yet. Now, this
It will
year,
be interesting also, they put up on their USCIS website the regional centers that they have terminated, right? So investors know, okay, I shouldn't invest in a project where this is being sponsored by this regional center and it looks like that regional center has been terminated. So it'll be interesting to see if in the future they publish the names of entities or individuals that they have debarred in these different capacities.
And it'll be interesting to see, in addition to the immigration implications, if this will serve, both with the SEC and with courts as also a way to help strengthen investor claims to seek restitution. Now, this year, Jen, you are chairing the American Immigration Lawyers Association EB-5 committee. And so you've been in communication with the government on numerous meetings on EB-5 related issues. Is there any insight that you have for our listeners, for our viewers, on what they can anticipate coming up in 2025 in the EB-5 landscape, related both to audits, site visits, and just in general, regional center and project compliance?
Well, I think the one thing is very clear is that the IPO office takes a very sort of hardline stance on compliance things. I think they have put time and effort when this law was being passed. I think the USCIS probably provided a lot of feedback to the congressmen who were writing this law. And a lot of the things that are found in the compliance sections are actual ideas of USCIS. And now they're there to implement those things. So they haven't given too much guidance on audits and how many they're doing. They also haven't really given us a lot of statistics on their workforce lately, although I do believe maybe a year or two ago, they released some statistics on the number of adjudicators versus FDNS officers that they have within the EB-5 office. And it was like 50-50. There's just as many people doing FDNS fraud detection activities as there are deciding cases at EB-5, so at the EB-5 office. So I think that's a signal of they are devoting a lot of time and resources to these processes. They need to go out, they need to fly to these regional center offices, they need to have a team there on site to review paperwork. They, I'm sure, have internal guidance about what to collect up. We don't know how many they have done so far. Certainly, there are reports of regional centers that have already been through audits since the RIA has passed. Many of them have said that it's being treated in the same way that pre-RIA audits were being treated, which is professional and detailed, right? So again, making presentations to the USCIS officers, getting them to sites if there are projects around the office of the regional center, getting them details about each of the projects and how they're doing a lot of due diligence on new projects, due diligence on the people involved in the new projects, due diligence on the investors. So they're very focused on these issues given the number of officers that they have in play to do these activities.
I remember when that data came out, we were all shocked that it was like, what, 28 adjudicating officers for just all investor and regional center applications. It was actually quite eye-opening and at the same time incredibly shocking in a very bad way.
And we
Because we have
know
to explain to our clients, why are there delays? Why aren't your applications getting adjudicated? Even I-956Fs in the recent Q&A released just today are taking 16 months when they're supposed to take 6.
it's true. And it's frustrating for the clients, but in terms of safety, it does promote a little bit more safety of investments. There's more sophisticated players in the market. So there's an upside and a downside to all of these things, but we know that USCIS is taking it very seriously. And we also know through various Freedom of Information Act requests that have been made to the USCIS that the EB-5 office coordinates with other government agencies to educate itself on different matters. We know that it coordinates with the Commerce Department on reviewing sources of funds for investors. We know that it has coordinated on various banking laws and anti-money laundering laws with other agencies. We know that it coordinates with FINRA and the Securities and Exchange Commission. So these other agencies are helping to form the knowledge of USCIS when they go into these audits. So it's really important to be prepared.
Yeah, lately we have seen that they're working closely with FinCEN and Treasury.
Yes.
Okay, so I want to wrap up, and I want to wrap up with the number one question we have been getting from our clients, which is how is the Trump presidency going to impact regional center compliance and the program overall? And of course, we've been explaining that the program is extended till September 30th, 2027. Anybody who files, whether it's a project or regional center, an investor before that date is subject to the current rules. But what do we see on the horizon?
I am not so worried about it, actually. I think the EB-5 unit of USCIS has been operating in the way that it has been operating for years now. And I think they develop these policies, they implement them, and they intend to keep doing that moving forward. I don't think that a new administration is going to change and make, there be less compliance. That's not going to happen. Will there be more compliance? I don't think so. I think there's already a lot of compliance. There's a lot to do. There's a lot of records to keep. And this law was passed by Congress. I don't think that it will be disrupted by the incoming administration. I think there's already a sort of this law enforcement based focus on EB-5, like this investigation into it, making sure that it's being done correctly. And I think that will continue under this new administration.
I'm also going to throw out there that we had more access to the EB-5 unit under the previous administration than we do under the Biden administration. Really, our communication and ability to dialogue, to email them has been blocked off under this administration. I will also add that processing times in my 20 years of doing EB-5 have never been as long as they have been under this administration in the history of this program. So I'm just going to throw that out there because I am also cautiously optimistic.
The one downside, I guess, of this, the RIA is that there is one section that kind of the USCIS is interpreting it that it forbids them from discussing internal matters and adjudications with members of the public. And they have taken that sort of to the extreme. And they're very secretive internally about how they are going to process things. And then they don't really take a lot of input from the public and stakeholders. They just go ahead and update their USCIS policy manual as it relates to EB-5. So it would be great under the new administration if they could relook at that and determine that it's okay to have stakeholder engagement again. The stakeholders have a lot of good ideas and a lot of good input for the program on how to run this more efficiently. And hopefully, under the new administration, maybe we'll get some of that.
Well, and also our statute was passed in 2022 and we still don't have regulations. And the goal of introducing and promulgating regulations is, of course, for the public to notice and comment on it. And as you said, we have a lot to add. There's different stakeholders involved in the program that have a lot to add. And with you as head of the AILA EB-5 committee, we're in good hands with getting the concerns of the immigration bar across. And we just want to be able to voice them and speak to them about it.
Absolutely.
Thank you so much for joining me today, Jen. It's always a pleasure, and I'm lucky to work with you and be your partner.
Very much the same.